The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hey everybody, Bryan McDonald from OnPurpose Growth here again for another Seize Your Business podcast. And today we've got Randy Micheletti of Incubate IP on. And what we're going to be talking about is if you own a business, no matter if you have you have IP, intellectual property or not, what we're going to do is we're going to be talking about some potholes that you need to be able to be aware of. So if you ever do develop IP in your business, you can avoid those potholes and actually monetize the intellectual property. So Randy, thanks for being on, and why don't you give us a little bit about your background and your company real quick?
Thanks, Brian. Thanks for having me. Incubate IP, I formed that out of a need that I saw in the market for young, small, growing companies to get great quality intellectual property services without having to pay enormous rates of the big city firms. Coming out of those big city firms, It was a real struggle to service small businesses effectively, which was a real shame. They needed the services at the early stages to make it work for them, but the rates were just insane.
Yeah.
And so Incubate IP is really mission driven to make sure that young startups and growing companies can get those services at a really high quality without having to, use all their operating capital to get it. So that's the mission.
So you're bringing that large firm expertise down to the level of the smaller guy who really needs that help.
That really needs it, yes. And in the large firms, I became somewhat of a specialist in fixing small companies' portfolios when they got bought by a larger company.
Okay.
So they make it to their exit and everybody celebrates and pops champagne. We would bring those portfolios in, servicing the purchaser, and realize, wow, these are in tatters. These are just in really bad shape. For a variety of reasons. Most of it had to do with budget. They were trying to use top-level services from top firms, but just couldn't afford it for good reason, because they needed that money to get the business running and get their products and services out on the market. And tying all that up in IP filings with big fancy lawyers and big fancy offices was just a real problem. So rather than working on fixing them for the rest of my career, I thought, well, this is crazy. Why don't we just do it right the first place? And so that was the genesis of Incubate IP, was to bring that service and make sure we can get it done correctly, properly, and nurture it in those early stages, so that when they do exit and they can pop the champagne, there's no nasty phone call the next morning saying, what did you just sell us? This is garbage, right?
And they can monetize it, right?
And they can monetize it. Yes, exactly.
So it sounds like what you're going to talk about here and what you've done is, with the structure of business, is help solve the problems prior to becoming problems, or as they surface.
Yes, and for a couple reasons. Not just it was a horrifying moment to look into under the hood after our clients had bought the car and realized there's no engine here, guys.
Right. Oh my gosh.
But also because it's really gratifying to help a young company. I spent a lot of time working for very large pharmaceutical companies as a big firm lawyer, which is great, very rewarding. I enjoyed it. However, after you get them their 500th patent, what's the 501st worth?
Exactly.
Probably not that much to their investors or their shareholders. So, for me, I feel like I'm making much more of a difference for the young company. That that first patent really makes a huge difference. It opens up financing, it opens up investment opportunities, it opens up licensing and product sales and all those things where they may not be available before. So for me, I get a big rush out of helping those companies really jump over that first hurdle. Maybe someday they'll get 500 patents, and I hope they do. But it's very rewarding to help them get that process started in the right path.
Well, let's talk about making that impact here with these steps that you've come here with. So, what do owners need to start thinking about in regards to their IP at whatever stage it's at?
Yeah, the number one problem I see when I visit with a prospective client or even some existing clients is that they, in their excitement of bringing a new technology from their brain into reality, they talk to too many people, and they talk to too many people without any protections in place before those conversations happen. Used to be here in the United States, if you showed your technology to the public or used it in public or even sold it before you filed a patent application, you were okay up to a certain point, and there used to be a grace period of about a year where you could still file your patent application and be okay here in the United States. That changed in 2013, where there is no longer any real grace period between the time when you talk about or use or sell your new technology and when you can still file your patent application. There's a still very narrow technical grace period available, but it's so narrow and so crazy that I don't even bother to tell my clients about it because you probably don't qualify for it.
Yeah, right.
And if you're in that space where you're hoping to rely on that tiny little grace period, I'm not doing a good job for you either. Right. So, for all intents and purposes, I tell my clients there is no more grace period for showing, selling, using your technology in public before you file your patent application. So
let's talk about this, unpack this a little bit, because people listening to this are probably thinking to themselves, well, I can't just tell anybody, or what are the activities they're doing that they may think are okay that it actually isn't in regards to telling people?
Yeah, it's a great question. So if you are talking about it and workshopping it within your own company, you're probably fine. And I say probably, that's like the lawyer's favorite word, right? But probably, because there is a difference, and we may get to this later on, there's a difference between employees and contractors and how the law treats who owns their innovations.
Got it.
So probably, if everybody's a W-2 employee, you're probably fine.
Yeah, right.
If you've got a mix of employees and contractors, you're probably not fine anymore.
Right.
So
Got it.
It really gets into the weeds very quickly about, what can I say even in my own conference room. But the basic rule, if you're only talking with your own employees, your own developers, your own vendors, you should be okay, assuming you have great contracts in place with all of them at some form. What's clearly not okay is, I'm going to a conference, I'm going to demo this new technology out on the floor of the conference. Even if it's, you have to pay thousands of dollars to get into the conference, that's still considered public. So, the best rule of thumb is, before you take it outside your own four walls, you should probably have that patent application filed.
Got it.
Just to be safe. There's again a lot of devils in the details there, but the basic rule is, before it leaves your own home, your own office, it ought to be protected by a formal filing.
So, dumb question, what about family and friends?
Yeah, family and friends, unfortunately, unless they work for you, that's public. So
okay,
yeah,
all right, good to know, right?
If you watch Law and Order, you see they go right to the spousal privilege argument like all the time.
Oh, really?
Right? Yeah.
I'd watch it, but I'll probably catch that now, right?
So in the criminal sense, the court can't compel your spouse to testify against you. That does not apply to patents at all.
Really?
So if your spouse, if your kids, if your uncle, your grandfather, whatever, even if they're funding your company, if they're not part of your company formally, that's public, and it can really be a disaster.
Okay. Yeah. That's interesting. So I'm glad we covered that.
Yeah.
So what else? So we're making sure we keep it quiet to certain people. We're not sharing with certain people. What else?
Yep. I see a lot of mistakes happen, especially with smaller companies, where someone inside the company is tasked with monitoring any incoming mail from the patent office or the trademark office. Okay. It's a great cost savings measure. You just set up your own address as the correspondence address with the filing office. But the problem is that the deadlines are mandated by federal law for responding to any of those communications. Okay. In most cases, they're not clearly spelled out in the letters you'll get from the Patent and Trademark Office. Sometimes they are, but in most cases, it takes some pretty complex algebra to figure out when a response is due. Yeah. Jeez. So if your company does not have access to and has not paid for an actual docketing system, a formal intellectual property docketing system, and most don't, that's really dangerous. So those deadlines come fast, and they are unforgivable in most cases. And if you blow one, your technology may be available to the public for free at that point, which is really disastrous.
So this is after you filed something?
After you filed, correct.
Okay.
Yeah.
All right.
Yeah. So I get a lot of calls, a lot of potential clients coming to me with, I'm not sure what happened to that. We filed it and we lost track of it. Can you dig into it? Sure. By the way, there's nothing you can do about it. It's gone forever. So that's a huge problem. It's one of those unforgivable moments where, all the work you've put into developing your technology, developing your products, developing your services could just be
falls through.
Yeah.
Oh my gosh. So where do they find these docketing systems? Through an IP attorney, or is there?
Yes,
okay.
you can just subscribe to them yourself. There are great options out there that are cloud-based, and so there's automatic backups built in. Most IP attorneys will subscribe to one of those anyway. And by naming an IP attorney as your attorney of record, all that correspondence is automatically going to go to them and get dumped into their docketing system with all that complex algebra built into those systems, right? So with warnings. So, I get pinged pretty much every Monday with, here's the deadlines for the week.
Really?
And here's the deadlines for next month, and here's the deadlines 2 months out, and here's what you need to be, reminding your clients, hey, I need information from you in order to respond to this on time.
Oh my gosh. That's...
Yeah.
We're only a little bit into this, and it's already very complicated. So we're watching who we tell. Yes. We're watching how to respond. What happened? What else?
Yeah. So then we get into this category of your personnel, your company's employees and staff, and especially your developers. Whether that's an employee or an independent contractor, I see a lot of hassle, and by hassle I mean expensive to fix issues pop up when people leave your company. For some reason, and I love the startup community, but the mentality seems to be right now that I'm starting this with my best friend and they're never going to leave me.
Yeah.
They will always leave you. I guarantee it. At some point they will leave.
It's guaranteed.
It's guaranteed. And so if you have not planned ahead for what happens when this person leaves, once they're gone, sometimes it's too late. I mean, in a great case scenario, they leave on great terms and you're still best friends.
Right.
In other cases, they left because they hate your guts now, and you're never going to track them down for a signature. And even if you did, they're going to hold you up for a ransom for that signature. And unfortunately, I've seen situations where key people in the development cycle of a new technology have passed away. And so what do you do then? Really? If you haven't planned for their departure in that sense, there could be real administrative headaches just dealing with the patent office and the trademark office and all those sorts of entities on who can speak for that person now.
So because that person knows of your IP, the patent office needs to could need to talk to them.
Yes.
And now they say, okay, that person's passed away. Who's going to represent them and speak for them?
Correct. So here's an example. I had a client years ago that one of the two inventors of a patent pending technology passed away. In his estate planning, he had actually taken the steps to say who's going to represent my estate afterwards, and it was his daughter, which was great. In the United States, at least, the patent system is pretty understanding about that. And so for the United States, we were able to use his daughter's signature as a representative of his estate. It was a lot of paperwork, but you're allowed to do that. The problem comes in with patent offices overseas that aren't really that savvy yet. They're still developing.
Nor do they care.
Nor do they care. And so we spent a lot of time and money working not just with the inventor's daughter, but also with overseas attorneys trying to figure out, they're asking for the inventor's original signature in ink on paper.
Not possible.
We can't get them that. What do we do now? And it was surprising to me how many other world patent systems don't have a contingency plan for that.
Wow.
And so, that unfortunately is one situation where, we can plan as much as we can. You still have to do everything you can to make sure that succession plan works, not just for your personal finances and your personal estate, but also for the technologies that you've developed as an engineer, as an inventor, as a co-founder of a company. So all of those things are important, and honestly, nobody thinks about it. When you're starting a company, that's not one of the things you automatically think about.
Exactly.
What's going to happen, to my technology when I leave the company or pass away. So very simple steps to take, though, in terms of building a succession plan, both personally and for your company too. That's something your corporate attorneys ought to be thinking about when you form your company, not after this person leaves.
Really?
Yeah. Oh, yeah.
So if you have some type of idea, product that's around intellectual property and you're launching a company, that's when you start addressing it?
That's when you should start addressing it.
Okay.
Yeah. Nobody does, and it's expensive to fix later. And so that's one of the things I like to tell all of my young clients is, have you thought about these things? You should at least, even informally have it written down somewhere in your planning documents or in your, operating agreement or somewhere. It should be somewhere so that someone can come in after the fact and say, oh, okay, they thought about it. Here's who can speak for that person, et cetera, et cetera. So sometimes when it's employees, it's as simple as having a really good, simple employee agreement in place that they sign on day one that spells out who owns what and who can take what technology with them when they leave. Sometimes it's more complicated. If they're employee number one, that gets real weird.
Really?
Sure. Yeah.
Why? Because they're because they've been there from the beginning. They have access to more information than the 50th employee or something like that.
Yeah, or it could be their original idea. So, for example, I had dinner last night with employee number one of a pharmaceutical company.
Okay.
And we got into that discussion of what happens if you leave. And it very quickly turned into, he kept asking questions, well, can I do research for the same disease? No, clearly not. Can I do research for a similar disease? Maybe. Can I do research for a completely different disease? Yeah, clearly yes. Right? So it gets very muddy very fast about when employee number one leaves. It was probably their original technology that spawned the company. When they exit, what can they do next? And the purchasers of that company certainly don't want him playing on the same disease,
right?
Trying to solve the same disease. That's why they bought his company,
right,
so that they could own that disease, cure.
And is there pushback from number one employee, like, hey, is there lawsuits involved, like, hey, like, now I can't go work somewhere or something like that? Okay. All
yes.
Right.
And so in a lot of cases that will turn on which state they're operating in.
Okay.
Some states are more friendly to non-competes than others. Illinois is kind of balanced. California is really one-sided, and other states are the other flip side of that. So that goes back to your formation. Where are you forming your company? Okay, if you live in Illinois, it's probably Illinois, but it doesn't have to be. Okay. Delaware is always an option.
Yep.
You don't have to operate in a specific state to form there, and there's sometimes some very good reasons for not forming in the state that you live in, and that's one of them.
Really?
If my plan for this company is to prove the concept, prove the technology, prototype it, and exit as fast as possible,
okay,
and then start over again, you have to ask yourself, is this the best state to do that? Am I going to be allowed to start over again, or after I exit, am I going to be prevented from starting over again on a new project?
Yeah. So this kind of falls, intertwines with employment law?
Very much so. Yeah.
Okay.
Yeah. And then it gets even more complicated. I know your head's spinning already.
Yeah, that's okay.
It gets even worse when you work with independent contractors instead of employees. So there's no basic rule with independent contractors over who owns what, as far as what they develop. And so that really boils down to what the language of the contract says. So to have an independent contractor, like the name suggests, you have to have a contract. And then it's whatever you guys agree to is who owns what. So I've seen many situations where a company will come to me and say, hey, we developed this with the help of a contractor. Can you write this up as a patent application? Sure, that's the easy part. Now deciding who owns it, that's complicated all of a sudden. And that brings us back to what we talked about in the beginning. When your company is ready to exit, what's going to happen is the purchaser of your company is going to dig into all those questions to say, hey, do they really own what they're trying to sell us?
Right.
That's easy when it's a house and you just search the public records.
Right.
That doesn't really work in the patent situation. So they're going to kick the tires pretty hard to figure out, are you really selling us what you own, or are there gaps in what you think you own that you don't really own? And so that has derailed more deals than I care to tell you about. Yeah, it's really, really sad
that's crazy.
You make it through the term sheet phase with a potential buyer. You agree on the major terms.
So close. You
are trading contracts, thick contracts for purchasing the entire portfolio of the company, and then you get to that stage where the other side's IP lawyer has kicked the tires and found out, oh yeah, they don't own the software that's in that machine.
No.
You can have the box, but you can't have the guts of how it works. And
deciding this happens prior to bringing on any employee or any independent contractor, establishing this,
establishing that, right?
Yeah.
So it's one of those situations where I think, to be fair, lawyers are expensive. We all are. That's just how. Sorry. But
that's what it is.
There's a good reason for it. If you get that good counsel early on an independent contractor agreement, it can save you so much money and possibly prevent you from falling into that pothole right before closing, exiting your company. Sometimes you can't fix it at that point. It's either too long, the engineer that coded that software isn't available, can't be found, disappeared, passed away, where you're now stuck in a situation of, there's nothing we can do to fix this.
And I mean, can you even rework contracts? Like, let's say you figure this out. Let's say, we come up with something, you hire me, the contracts aren't structured the right way, and 6 months down the line, you figure this out and you got to rework the contract. Is that possible?
It's possible. It'll go one of two ways. Either it's really, really expensive in terms of lawyer time to fix, and I'll give you an example of that in a second. The other way it can roll out is that the price that a buyer is willing to pay for your company just went way down. So you may have had $1 million offer to buy your company, and then as they kick the tires, they realize, wait a minute, we only get the box, we don't get what's in it. Your acquisition price just went down to $200K or something like that.
Yeah.
So the horror story I have on this is exactly software inside the box story. A client of mine years ago was purchasing the assets of a foreign company that was in receivership. So they had kind of run their course. They had shut the doors, but they had a really cool hospital technology, digital technology for hospital use, patient care. It was essentially a heart monitor. So you see the medical dramas where it's going beep, beep, that thing. So this company had developed a really interesting version of that, and my client wanted to purchase it. The whole portfolio of it, the box, the rights, the name, everything, all involved. So we're kicking the tires in that situation because our client's writing the check to buy this stuff, and we realized the software engineer that they used was an independent contractor and had not signed over his rights to the finished software product. Okay, we can deal with this is the first thing that goes through my head. So I track the guy down, I get him on the phone, and we spent probably 8 to 10 hours over the course of 3 months on the phone with him, trying to convince him that we weren't trying to rob him of all of his pieces of code. We didn't want the pieces of the code, the tools in the toolbox. We wanted the completed toolbox with all the code lined up, and getting him to the point where he felt comfortable that we weren't trying to put him out of business as an independent contractor. It was a phenomenally expensive,
I can imagine,
time-consuming, and the deal got delayed by 3 months. And so our client, who had already, touted this to their board of directors, look at this cool new product line we're going to have, and give it to their sales reps already. They're out there, selling this like crazy into hospitals. Oh, sorry, we can't deliver on that for we don't know how long. Everything's hung up with the lawyers, right? Everything's hung up with the lawyers.
It's your fault.
That's right. It's always our fault, right? So phenomenally expensive, and nobody left that situation happy or feeling like they got value for it, because it was all duct tape and Bondo to try to fix this thing after the fact, right?
So taking the strategy of, don't worry about it, we'll fix it later, doesn't necessarily work in this situation.
Really unadvisable.
Yeah. So what else do we need to know as we wrap this up?
So a related topic on that, very simple things that can help you smooth that transition from term sheet to closing of a deal is to make sure that every time your company changes address, name, ownership, whatever, that you're updating not only your records with the Secretary of State's office, wherever you're located, but also with the Patent Office. So we have a public directory of all ownership assignment documents that we record, just like you record the title to your house or any of that sort of stuff. There's a public database for that in the Patent Office, and that's the first place that a purchaser of your company's lawyers are going to look to start kicking the tires. Very, very simple to get that right and keep it updated. Very cheap. The Patent Office doesn't even charge you a fee for filing documents there, which is kind of crazy. It's the one thing you can do for free in the Patent Office. So from that standpoint, there's no reason not to do it. It's so simple to get that done. But every single deal I ever worked on at the large firms in the city, I was finding problems with this. It was address, it was ownership, it was, a previous investor had filed a lien and never released it. That was so common, and none of that. We can't bless the deal until all of that is cleared up, and that's time, money, all of those things, right? So
that's amazing. Super
simple to get that stuff done right, kept up to date. Takes almost no time at all for an attorney,
right.
and so for the $100 or $200 every time you make one of those changes to your company's name, status, location, whatever, it should be automatic reflex for you to send that information to your patent lawyer and say, can you please update the records on file with the patent office with our new information.
And I mean that $100, $200 could turn into thousands, hundreds of thousands, or millions. You never know, right?
That's right.
Well, Randy, I appreciate it. This was very enlightening. Some very simple things for people to understand and apply that solve some very large issues, right? Meaning getting their monetizing or not, or monetizing to the maximum value. So I appreciate you coming on.
Thanks for having me, Brian.
Thanks, everybody, for tuning into this episode of Seize Your Business Podcast, and look forward to seeing you guys next time. Take care. Cool. Awesome, man.
Thank you.
Great. That was great.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.